This podcast is published solely based off the interests of Jacko Law Group, PC, and in no way be construed as legal advice. The opinions shared reflect those of the authors and not necessarily the views of Jacko Law Group, PC. For more specific information or recent industry developments or situations, you should seek legal opinion or counsel. You are hereby notified that any review, dissemination, or copying of this message and its attachments, if any, is strictly prohibited. These materials may be considered attorney advertising in some jurisdictions.
Welcome to Jacko Law Group's Regulatory Compliance and Corporate Law Podcast. I'm Jeremiah Baba Pagano, attorney at Jacko Law Group. Today, this podcast is going to help us break down the complex regulatory, compliance, securities, and corporate law topics for business owners and professionals just like you. Last week, we brought you part one of our discussion on financing capital and various ownership structures. Today, we're going to dive into part two. We will be reviewing various ways that different capital methods can be important when considering a potential merger, acquisition, or similar purchase transaction. When choosing the right structure for your specific needs, it's best to create financial protections over a multi-year period. Our team at Jacko Law Group specializes in assisting individuals and companies in the preparation and the ongoing tailoring of their 3 to 5 and 7-year business plans. This includes capitalization and fundraising scenarios and similar growth-related needs. But today, let's just focus on financing. Here are a few examples of the many options that can be considered during a potential merger, acquisition, or similar purchase transaction. First, we have cash on hand. This can permit you to provide the seller with a sizable down payment, which the remaining portion of the purchase price can be provided as part of a promissory note. This can either be between the parties or as part of a third-party financing. In pursuing such option, the borrower may have the ability to negotiate certain terms associated with the promissory note. This can include the repayment time periods before the maturity of the promissory note, the interest rate, or whether the promissory note will be secured, all of which are key repayment terms for this transaction. Another option is institutional financing. With interest rates historically low, local or national banks can be a good choice if available to a party for financing. For example, if a party to a transaction currently has an established business relationship with a local or national bank, then that institution may be willing to afford financing opportunities that otherwise may not be available to other owners. For example, the Small Business Association or the SBA may be available for some qualified business owners to offer SBA loans. These types of loans can provide lending to cover a sizable portion of the purchase price. However, it is very important to note that SBA loans may not be available to all businesses or entrepreneurs. Instead, it is only available to those who satisfy various lending requirements that are established by the SBA. Lastly, another option that can be available is through mezzanine financing. This can consist of customizable loans that can extend over a period of time and can provide a number of financial resources to the business, such as allowing a business to defer the principal repayment of the loan or allowing the business and borrower to request additional advances on the loan as agreed upon by the parties. Determining the best financing option for your acquisition is a complicated decision through the M&A process. Peace of mind can be even more valuable than the cost of any acquisition. To find out more and to speak with our team, we invite you to contact us at 619-298-2880 or find us online at jackolg.com. Thanks for listening. We hope you have a great day.